Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On June 15th, the court decided Golan v. Saada, holding that a court is not categorically required to examine all possible ameliorative measures before denying a Hague Convention petition for return of a child to a foreign country once the court has found that return would expose the child to a grave risk of harm. Joining today to discuss this case and its implications is Professor Margaret Ryznar of Indiana University's McKinney School of Law.
This is the fifth U.S. Supreme Court decision in the last decade or so on international child abduction by a parent. The rise of these cases corresponds with the rise in both international marriages and divorce rates. In this case, the U.S. Supreme Court further interprets the 1980 Hague Convention on the civil aspects of international child abduction, which requires the prompt return of children to their habitual residence from the country to which they are wrongfully removed to or retained in. It is important to this case to note that the Hague Abduction Convention is purely jurisdictional, and any substantive legal issues between the parents must be decided by the court system in the place of the child's habitual residence. In this way, the Hague Convention prevents international forum shopping by denying abducting parents home court advantage for the child custody dispute. Now, the term habitual residence is not defined in the Hague Convention, but a court will look to several factors, including the child's birth country, the country from which the child was taken without the other parent's permission, and the existence of any coercion by one parent on the other into the exchange. Now, there are several exceptions under the Convention to the prompt return of an abducted child to the habitual residence, and one of those exceptions takes center stage in today's case. This exception is found in Article 13 of the Convention, which says that the return of a child to the habitual residence is not required when there is grave risk that the child's return would result in physical or psychological harm or place the child in an intolerable situation. The American mother in this case is invoking this exception to keep her young son in the United States instead of being returned to the child's father, who is Italian and lives in Italy. She is invoking this exception based on the record of physical abuse in the relationship that the child witnessed, which drove her to stay in the United States with the child after attending her brother's wedding there on what was supposed to be a quick trip from Italy. Prior to this, the mother and child had lived in Italy with the child's father since the child's birth. The child's father immediately, of course, initiated a criminal complaint for kidnapping in Italy, a civil proceeding seeking sole custody in Italy, and then also a petition in New York for the return of the child to Italy under the Hague Abduction Convention. Now, none of this is in dispute, but what is in dispute is the Second Circuit's rule that applied in this case. And that rule is that the trial court must always consider any and all measures that will reduce the risk of harm to the child before refusing the return of a child based on the grave risk of harm. The Second Circuit's rule is based on the view that the convention requires return of the child if at all possible. So as a result, the district court in this case had required the parties to propose ameliorative measures that would enable the child's safe return to Italy. The court then accepted several conditions proposed by the father for the return of the child to Italy, which included living separately and attending cognitive behavioral therapy. On appeal, the Second Circuit found these measures to be insufficient to mitigate the risk of harm to the child if returned to Italy. The problem was that the Second Circuit doubted that the father would comply with these conditions and determined them to be unenforceable. The Second Circuit thus remanded this case back to the district court to consider whether there are alternative ameliorative measures that are either enforceable by the district court or otherwise guaranteed to be performed. So then the district court spent 9 months extensively examining the measures available to ensure the child's safe return to Italy. In the end, the district court relied on an Italian court to order that an Italian social services agency oversee the father's parenting classes and therapy, as well as that visits between him and the child be supervised. The U.S. District Court concluded that these measures were sufficient to ameliorate the harm to the child and again granted the father's petition for the child's return to Italy. This time, the Second Circuit affirmed. Now, the U.S. Supreme Court did grant cert to decide whether ameliorative measures must be considered after a grave risk finding. The U.S. Supreme Court ultimately decided that ameliorative measures can, but need not be, considered in denying the return of a child based on a grave risk of harm. As Justice Sotomayor writes for the unanimous court, nothing in the convention's text either forbids or requires consideration of ameliorative measures. While district courts have the discretion to consider ameliorative measures that could ensure the child's safe return, they do not need to do so according to the Hague Convention. Thus, the Second Circuit's rule requiring consideration of ameliorative measures actually rewrites the convention. Furthermore, the Second Circuit's rule, by instructing district courts to order the child's return, if at all possible, improperly elevated return of the child above the convention's other objectives. However, the Hague Abduction Convention is designed to protect the interests of children and their parents, and children's interests may point against return in some circumstances. The Supreme Court points out that these interests constrain courts' discretion to consider ameliorative measures in at least 3 ways. First, any consideration of ameliorative measures must prioritize the child's physical and psychological safety. A court may therefore decline to consider imposing ameliorative measures where it is clear that they would not work because the risk to the child of return is so grave. Second, consideration of ameliorative measures should not usurp the role of the court that will adjudicate the underlying custody dispute. This is because the Hague Abduction Convention is only about determining the jurisdiction of the custody dispute, not the actual custody dispute itself. So a court ordering ameliorative measures should limit those measures in time and scope so as to permit a safe return. Third, courts considering ameliorative measures must nonetheless act expeditiously in proceedings for the return of children as required by the Convention. This is to facilitate prompt custody proceedings in the child's habitual residence. A requirement to examine the full range of options that might make possible the safe return of a child is therefore in tension with this focus on expeditious resolution. In sum, while courts may decide to consider ameliorative measures where appropriate, they can also decline to do so when not raised by the parties, it is unworkable, it draws the court into determinations properly resolved in custodial proceedings, or it just risks overly prolonging return proceedings. The court may also find the grave risk to the child so unequivocal or the potential harm so severe that ameliorative measures would be inappropriate. The U.S. Supreme Court then remanded the case to the district court with the note to move as expeditiously as possible to avoid further unnecessary delay, which has already amounted to years. This case is helpful in further interpreting the Hague Abduction Convention, and it highlights the priorities of the child's safety, as well as the quick resolution of such cases for the benefit of the children, so they are quickly returned to the place of their habitual residence, where the child's custody determination can then be made.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.